Good morning, Your Honors.
Good morning.
May it please the Court. Jeff Manners on behalf of the appellants, Bruno, and with me, the brain trust of the firm, Gene Neal. The record in this case, this is the Fair Labor Standards Act overtime case.
Counsel, do you want to reserve some time for rebuttal?
Please, 3 minutes. The facts are clear. The settlement agreement at issue was submitted to the trial court judge on April 12th and April 18th, 2012 for review.
But the trial judge did not retain any jurisdiction for enforcement purposes of the settlement itself. In other words, this wasn't like a consent decree or a settlement where the trial court has to monitor some kind of payments and some kind of compliance.
I understand that, but I would respectfully disagree.
Well, what was the trial court enforcing in this case?
Much. In other words, as soon as we went through the interpretation argument to see if an agreement existed or not, the court went one step further. It found that an agreement did exist and took judicial control over the agreement. In fact, as soon as the judge ruled from the bench that there is a settlement agreement between the parties that I'm going to enforce, opposing counsel respectfully said, well then, pursuant to the terms of the settlement agreement, have Mr. Manners order Mr. Manners to immediately dismiss with prejudice the claims in this dispute. The judge said, Mr. Manners, that's the terms of this settlement agreement. I'm enforcing it. You're ordered to now go ahead and voluntarily dismiss the portion of the case subject to my retaining jurisdiction over the enforcement of the remainder of the settlement agreement. That's judicial imprimatur per se.
What was left to be enforced?
What was left to be enforced? One, that in fact plaintiffs voluntarily dismissed with prejudice the underlying claims. That was done 5 days later. Then what was left to be enforced, and it was explained in our voluntary notice of dismissal, what was remaining was that under a Fair Labor Standards Act case, under these unusual circumstances of first trying to disavow the settlement agreement, the court looking into the settlement agreement, finding it exists and enforcing it and interpreting it to exist, what unnecessarily or awkwardly was left was the Lynn Food Store analysis that any overtime claim must be analyzed for fairness. It has to go through a fairness determination. To have the release, to have the notice of voluntary dismissal have any significance in law. Otherwise, there's no significance.
So the trial court to retain jurisdiction to do all of those things and said that in some kind of final judgment or consent decree where it said, I'm going to do all these things. I'm going to do a fairness analysis. The settlement agreement was already approved by the time the action was dismissed, was it not?
Yes, but...
So what fairness analysis was left to be done?
In other words, what we're saying, I disrespectfully disagree with the myopic
no,
view.
I think you respectfully disagree.
Not disrespectfully.
Freudian slip.
You were one word ahead of yourself.
Syllable over the top. I'm sorry, what was the question? I'm sorry.
The question is, by the time the dismissal with prejudice was entered, was there some judgment entered by the trial court saying, I'm going to look into the fairness of this? Hadn't that already had to have been done at that point? Otherwise, there wouldn't have been a dismissal. There wouldn't have been any of this, correct?
Our position is that there comes from a judge on the bench rulings, and that those rulings from the bench themselves constitute judicial order. That what the judge
Counsel, this is really not complicated dance. The case law governing this kind of action says how a trial judge reserves jurisdiction to do more, which is either enters a consent decree, which requires the judge to supervise on his own, or there's a settlement that the trial judge adopts and incorporates and says, I'm going to supervise. In the final judgment, in your final judgment, what is left for the trial judge to supervise or do?
Since it was raised at the hearing by myself that the fairness requirement was still left unresolved, that had to be preserved, and then
Did the trial judge, in a final judgment, reserve jurisdiction to make a fairness determination at some later date?
From the bench, yes. From her one
Is there a
page-
piece of paper, counsel?
No, Your Honor. No, there is not.
Can
And
I
if we-
ask you a question with respect to the mediator? Because you went to mediation, and that's where you entered into the settlement agreement, and the mediator filed a report and notice of settlement. And in that report to the court, she notes that you had agreed to and executed a settlement agreement and resolved all the issues with the exception of the fees and costs. So that was still left out there, and that had been, the trial court had been advised that that was still a piece that was outstanding.
Correct. And that apparently was becoming a major dispute between the parties and unresolvable by the parties themselves.
But what does the case law say about if that's the only thing that's not resolved? Does it say that
The court retained jurisdiction over the resolution of the case. The court wanted the settlement executed. It wanted a dismissal entered with the court retaining jurisdiction to monitor the balance of the action between the parties, including but not limited to the attorney's fees dispute.
And the court confirmed the settlement agreement, correct?
Yes.
At the hearing, I think you brought up, if I remember right, Judge, we still have to talk about the equity of the agreement, et cetera.
Correct.
And the court said, I'll confirm the settlement agreement at your request.
And that's exactly what we did. A month later, 2 months later, that was in April, and in June, we filed the motion to determine fairness of the settlement pursuant to the Lynn's Food Store case, which required a very standard analysis in overtime cases that in fact occurred on August 20th before the judge. There's no record of that hearing, but the paperwork supporting that motion, supporting that hearing, supporting the 2 orders entered on that, confirmed that the trial court judge then went ahead and enforced and found valid, in essence, the notice of dismissal and the release of all claims. Hence, more judicial conduct, not in the form of a one-piece page of paper on 4 corners. I accept that.
But why, I guess my question is, when you filed the notice of voluntary dismissal in April of
Yes.
2012,
Yes.
you do it subject to the court retained jurisdiction for the purposes of determining prevailing party and the reasonable amount of fees and costs.
Inter alia, I stuck that into, but yes.
But
yes.
you don't include the other issue, which is the fairness determination.
I have never gone through a case like this before, and honestly, at that point in time, there were things outstanding that were referenced to the trial judge and no one was clear on. The parties couldn't agree on whether or not, in fact, that issue had been raised or not. So when we filed our motion to determine the fairness of the settlement, we put our position that, in fact, it had been discussed with the parties, and we were still waiting for defendant to provide that.
But it's a very, and I understand your position, but it's a very unusual posture to dismiss a case with prejudice when a fairness determination, that's a big issue. That's not just jurisdiction for fees and costs. That's still a big piece of the puzzle that's still out there.
It's like the case isn't over,
Right.
but there's just a dismissal with prejudice. If the case isn't over, then you can't dismiss with prejudice and just leave the fee issue open. And, the case law, federal case law is that if the trial court doesn't keep something there to monitor, it's over.
As the court is ordering me, pursuant to a defense counsel motion, to dismiss the case, I feel like the jilted girlfriend after the you know what I'm saying?
Your problem is you feel like you got caught in a bind and you're caught in a vice based on the court order and what was the intent of the parties. And so now you're suffering what, apparently, you're arguing you're suffering what the court forced you to do.
Correct, in good faith.
Counsel, I need to ask you a question. There was a request for a class certification here. How many employees are at this restaurant? How many are we talking about?
A total of 8, and only 2 joined out of those 8.
So there was a move to make this a class action for 8 people.
Not within the meaning of our state civil rule, but within the meaning of the Fair Labor Standard Act that's much more liberal, loose, and therefore conditionally certifies pretty much any class at the drop of a dime, realistically.
Thank you, counsel.
Thank you very much.
Thank you.
Good morning, may it please the court.
So this was a trick.
I'm sorry?
So this was a trick. In other words, there was much more to be done, and, it was a trick to get a dismissal with prejudice without the trial court reserving some kind of authority over further enforcement of this deal.
Respectfully, Your Honor, we had a settlement agreement. It was drafted by attorneys. The mediator was an attorney. All the parties understood at that time, or at least our client did, that this was the end of the case. It was completely over. There was only one issue left, attorney's fees for opt-in, the class, the two people that came in the class. Those were the only people that were left in this, and we didn't believe that they were employees in the first place. So we figured that, and we had a 57105 motion hanging out there, which we were holding jurisdiction open under the settlement agreement to have a resolution of. So the only issue left after the settlement agreement was signed by all the parties was whether or not there were any prevailing parties, or whether these employees, these opt-in employees, were in fact employees at all. We don't believe that there was any violation of the Fair Labor Standards Act at all.
The issue after the settlement agreement was whether or not they were employees, but yet you settled the case and paid?
We went to 2 hearings in front of Judge Platzer.
I understand
regarding
that.
the
My
settlement
question
agreement.
to you is, you have a settlement agreement.
Right.
And I just want to make sure I'm understanding you correctly.
Sure.
Are you saying despite the settlement agreement, there was still an issue of whether or not they were employees? If that was the agreement, why was there a settlement agreement? Well, if that was the issue, why was there a settlement agreement?
All of the issues between the parties were resolved in this private mediated settlement agreement.
Okay.
The only issue that remained outstanding was whether or not the two people that had opted in were even employees of the supposed Fair Labor Standards Act
Did you settle with
employer.
them?
I'm sorry?
Did you settle with them?
We paid them nuisance value. I guess that's a
What,
settlement.
the nuisance value was what, $8,500?
Nuisance value
And
for- in those
you had made an offer of judgment for how much?
$500.
$500, and you paid $8,500 at mediation.
Let me just
So that's
clarify.
a little bit more than nuisance value.
Let me just
don't you think,
clarify
Counsel?
that one point, if I might, Judge Suarez. We had paid the two opt-in plaintiffs, I think it was a total of $1,500 each.
Okay,
The offer of judgment that we had initially filed was filed at the very beginning of this case.
Right.
And it was as to only the one plaintiff that was involved in this case at that
Okay.
time. That was it. And there was some claim at that time that he may have been, overtime might not have been paid for 2.5 hours that he worked during an almost a year period. So we're talking about $12.50 worth of unpaid overtime. And we did an offer of judgment at that time for $500.
then why was the case settled?
The case was settled because it had run on for years and.
That's right, it had been fought tooth and nail
Correct.
on everything, am I
Correct.
correct?
That's
Everything was
absolutely
fought.
correct.
So attorney's fees are running like mad
On both sides.
on both sides on what started out as a county court case under $15,000.
Correct.
And
The class action
Class-
certification requested for 8 people.
Correct.
And I'm still going
It
back.
wasn't our certification. I'm sorry, Your Honor.
I'm still going, that's all right. I'm still going back to, if what you're saying is you still had to determine whether or not they were employees, I still don't understand why the case was settled. Why'd you stipulate to a settlement?
Nuisance value, you wanted to get rid of it.
That's exactly the reason. We just didn't want to spend any more money. The client did not want to spend any more money defending this case. So they settled it for whatever they could just to get out of the case.
Okay.
And it ended up not being that way because all of a sudden there was a disagreement
on
about the
another
settlement
life. It
agreement.
took on another
We
life.
went on to hearing after hearing and then finally to the new judge, Judge Rosa Rodriguez, who had what was set for a 3-hour evidentiary hearing on a motion to determine prevailing parties, and there were several motions pending at that particular hearing. There was Mr. Manner's motion, and then there were our motions to dismiss one of the defendants. There was a motion on the 57105 motion. There was a motion on the offer of judgment. All of these motions were pending.
Right.
And the judge ruled on the one issue, the main issue as far as our client was concerned, was whether or not the plaintiff was a prevailing party, and she said no. And so at that point, thank you, Your Honor, we're going to withdraw our motions for right now. We're just going to sit and that's the end of the case. And that's what we hoped would be the end of the case. And so here we are on an appeal, having run again more attorney time. The problem from our perspective is that the Fair Labor Standards Act cases are a cottage industry in the Southern District of Florida. There are more cases here than anywhere else, and it is, I think, the case law which has swung too far to one side, which has promoted those
Well, that's not
filings.
really
Well,
the
other
issue
than the
here. That's not
philosophy,
issue
this
here.
case was dismissed with prejudice, with the trial judge not reserving jurisdiction to do anything.
If I can just mention one
a
point,
problem.
just since I've been peppered with questions here. In this case, the parties entered into a private settlement agreement, and thereafter the case was dismissed. The dismissal, however, did not incorporate the terms of the settlement agreement or retain jurisdiction to enforce the settlement agreement. It merely attempted to retain jurisdiction on fees. Similar to the case we attached to the answer brief,
What are you citing from?
Mayer versus Wall Street Equity. The case is 2013, Westlaw 1235537, which is an unpublished opinion which came out in March this year, where Chief Justice Moreno, on behalf of the court, entered a final order of dismissal, an actual order by the court. And the final order of dismissal failed to incorporate the terms of the otherwise retained jurisdiction, or failed to incorporate or otherwise retain jurisdiction to enforce the settlement. The 11th Circuit noted that while the court's deficiency in its order of dismissal may have been unintentional, this did not change the fact that the order failed to satisfy the Fair Labor Standards Act's general judgment requirement or the 11th Circuit's specific requirement of a stipulated consent decree enforcing the settlement. So the case, and as I was talking about with the pendulum swinging, it's swinging the other way now. And so,
Well, I mean, there's a couple of other cases that, Kimmel Arts, and there are some other case law that sort of suggests that. All right, counsel, thank you. We
Thank you.
understand your argument.
thank you, Your Honor.
Counsel?
Thank you, Judge. The court is correct. The final order didn't retain jurisdiction to incorporate and formally follow the terms of the settlement agreement. But the big picture here was that there was judicial imprimatur as the court upheld settlement and interpreted it over defendants saying it should be chopped, voided, and discarded. Now, we have cited to the Zessar versus Keith case, which states in some, it's not the holding, but it's at the conclusion paragraph, in some cases will sometimes arise where, despite there being no final judgment or consent decree, the legal relationship of the parties will be changed due to defendants' change in conduct brought about by a judicial act exhibiting sufficient finality. When someone comes to the table and litigates for $500 as their settlement offer for 2.5 years, and then a trial court judge strikes their answers with prejudice, then the trial court judge reorders their witness, their defendant, to come in for a second deposition with sanctions and
Counsel,
fees.
there's no question in this case that the owner of this restaurant was just, as my grandmother would say from the South, madder than a wet satin hen. He was absolutely torn up about the fact that these employees would dare ask for this money and absolutely wouldn't cooperate in any manner. We can get that from reading the record. So we understand how this all got litigated up to this point. So we realize what happened prior to this.
The surrender, based on the court's actions, the surrender, all right, I'll give them $8,500 for it to go away, with us clearly saying at all times, but there's now a problem with attorney's fees. That was on the table. That was clear. The mediator said so. So for their argument to say that now attorney's fees are gone, it's just not equitable or fair.
Thank you, counsel.
Thank you, counsel. Thank you both.